Hello, I'm David Roger, General Counsel for the Las Vegas Police Protective Association. Last week we talked about legislation and case law dealing with identifying passengers. And we talked about how if you don't have reasonable suspicion to believe that a passenger has committed a crime, you may not demand identification. But you may ask for identification, and if the person voluntarily turns it over to you, so be it. But we also talked about a federal case against some metro officers that deals with asking passengers for identification and unreasonably prolonging the length of the detention. And the case of Matthews versus Las Vegas Metropolitan Police Department was such a case. As you'll recall, we talked about how the officer pulled over a van for a traffic violation. When the officer went up to the van, he found that there were 10 occupants in the van, and they said that they were going to a Mongols motorcycle club meeting. And so the officer asked for everybody's identification. They provided it to the officer. Backup officers arrived, and they began running the identifications for records checks. And the fact was that the detention was prolonged about 15 minutes or so in order to conduct all the background checks, and the federal district court judge, Jonathan Boulware, found that that was an illegal detention because the detention lasted longer than what would take an officer to write a citation for speeding. What caused some concern among officers, rightfully so, was our discussion about qualified immunity and how the judge decided that the officers were not entitled to qualified immunity in that case. And so the question became, how could a judge decide that officers were not entitled to qualified immunity? And so I've been asked to do a follow-up video. Qualified immunity is immunity from having to stand trial, and so it is immunity that allows an officer to go about their job without having to defend his or her actions in federal court. But it is a preliminary finding by a judge because qualified immunity means that not only are your actions appropriate, but you don't even have to stand trial. You don't have to look a jury in the eye and explain why you did what you did. And so this is what the court wrote in the Matthews decision. Qualified immunity is an immunity from suit rather than a defense to liability, and ensures that officers are on notice that their conduct is unlawful before subjecting them to suit. In deciding whether officers are entitled to qualified immunity, courts consider taking the facts in the light most favorable to the non-moving party, which means the officers, whether one, the facts show that the officer's conduct violated a constitutional right, and two, if so, whether that right was clearly established at the time. Under the second prong, courts consider whether a reasonable officer would have had fair notice that the action was unlawful. While a case directly on point is not required in order for a right to be clearly established, existing precedent must have placed the statutory constitutional question beyond debate. This ensures that the law has given officials fair warning that their conduct is unconstitutional. And so in this case, Judge Boulware said that the case law is pretty clear that you may not unreasonably detain a person past the original reason for the stop, and that running people for warrants was unrelated to the initial stop, which was to cite the driver for speeding or whatever traffic violation. As a result, Judge Boulware required the officers, or requires the officers, to stand trial and go through a jury trial. Thus, they are not being given qualified immunity. I hope that explains things, and obviously it should cause you to talk at briefings and with your squad on whether you want to go down this path and ask passengers for identification. do you want to continue FIing or field investigating or field identifying individuals if they're not consenting to your interaction with them? So I know it causes a lot of consternation and causes you to ask a lot of questions about the way you perform your duties, but that is the world that we live in with respect to law enforcement. As always, if you have any questions, please email me at droger@lvppa.com, and always make sure that you have my number as well as davidroger.us in your cell phone. Thank you.